The president, if he orders a criminal indictment and says, prosecute this man because he is black, I don't like black people, is that illegal under the Constitution? Prosecute this Jew because he's Jewish.
Does it violate the Constitution is what you're asking?
You should, yeah, of course it does, right?
Yeah, it sounds like it does.
Okay, that would be an illegal action. If they said, okay, now let's go after the president. We have him on tape saying prosecute this guy just because he's Jewish. This immunity doctrine comes up. What's the result? The result is, of course, he's immune, isn't it?
Yeah, of course.
That's an example of the immunity protecting illegal action.
Well, no, it's illegal in general. It's not illegal for him to do it in the criminal sense.
The immunity doctrine is protecting him for that, even though he is without authority to do so. Why? Because apparently some part of the Constitution is more important than the other. And that's what I mean. Hey folks, please like, comment, and subscribe. And make sure to check out my newsletter. Information is in the description.
The experience, and maybe this is just pivoting now because we found the point of agreement, was really valuable because, well, on a few levels. One, it's a really different way to have a conversation because, like, just to be like the arrogant asshole and just make the obvious point. On the entirety of political Twitter, Twitch, whatever it is that I've seen, you and I probably are capable of having the highest level conversation about this topic. Like, I think we're going to go very deep into weird flow charts and like fringe areas, and it's going to get very nuanced very quickly when we argue about this, and it has in the past. And that's fun.
Which is what I wanted, by the way. I want to be clear and just be all my cards on the table. I had fucking no idea. Like, and listen, you have to play the cards you dealt. I'm stupid for not like looking closer at the chat. I like didn't respond multiple times because that's totally. I mean, I'm not trying to push off responsibility. That's what I wanted with you. Like, I'm trying to have a conversation. You know, we have a moderator there, whatever. They just organized it, and I wanted to have a conversation in the weeds to almost like prove to you that you're wrong and prove to other like a technical audience that you're wrong. That's what conversation I wanted to have. But and hopefully we can get into some of these areas today or some other time. But
yeah, of course. I'm always happy to have a conversation. It's just it's very different, right? Like you called me out on this, and it's of course true. Like, in the way that I'd approach a conversation with you, like some random night like tonight or whatever, and you're like, hey man, I want to talk about the SEAL Team 6 hypo, right? Mm-hmm. My answer is going to be different than if we're doing a formal debate about the proposition, was the case rightly decided? Because in that context, I'm always going to say they didn't decide that, right? Because like in the context of a debate, I'm not interested in exploring the thought experiment. I'm interested in defending the proposition, and I won't let you expand the proposition beyond what I think it should be. And you can try to push on the judges and say that I should defend it. But the approach to those conversations is completely different, right? Like, I mean, they're not the same conversation.
So I disagree. Why do you think that the judges ask such hypotheticals if you don't think they're related to the correct rules? Surely the way that a principle of constitutional reasoning, how that could be expressed in different situations, and whether or not, so for example, like some kind of commerce clause limiting principle, these hypotheticals aren't just there to like for fun. I mean, the judges are asking them specifically to ascertain whether the framers could have intended such a thing. So I do not think that these hypotheticals are irrelevant. I think they have a tendency to show whether a particular interpretation of constitutional theory is correct. And so I don't know how you could possibly justify what you just said.
Well, no, I'm not trying to convince you that they're irrelevant. What I'm saying is, tactically, in a debate where you're defending a proposition, or in court you're defending a point, right? Mm-hmm. The obvious defense for my position in there is to say they didn't rule on that. I'm here to defend their ruling. They didn't rule on that. That is the first argument. The thing is, if you and I are having a conversation and we're just working through the hypotheticals, what would a court do if X, Y, and Z happened? That's a very boring thing to say, and we're not going to have an interesting conversation, and I'm not going to get to like work through the hypos and like learn and explore the ideas. So it's like my approach to a topic like that is totally different in a formal debate versus a casual conversation.
This thing could be turned back on you, Ryan. I could just quite as easily say they didn't rule on whether it's, and they wouldn't have ruled on whether or not to criminalize a pardon. They didn't rule on that because it wasn't before them whether or not a pardon could be or could not be criminalized. So
it
it's
was already
just
ruled on in 1870.
no, not directly and in so many words, and I think that you're aware of that. But it's talking about specifically criminalizing the act of giving a pardon. That wasn't ruled on in 1870.
No, but whether Congress has the power to regulate the pardon
Right.
was.
So all of these hypotheticals and all these extrapolations, they're related to the underlying question. Of course they are. And
No,
don't act like you're above it in the context of a formal debate.
Is.
You brought it up, something that hasn't been specifically ruled on.
The difference between the pardon, which was like a full paragraph of the court's analysis that they spent time on and used to build their immunity argument,
did they
versus
specifically rule on it?
The SEAL Team 6 hypo, which was not even, you can control F domain opinion.
Rule on it?
It's not there.
Did they specifically rule on it?
I'm not saying, I'm not even saying, I'm saying like the SEAL Team 6 isn't even dicta. It's not even part of the opinion. It's just not there.
I'm a machine right now. I'm just saying, did they specifically rule on whether criminalizing a pardon?
It was not the holding of the case.
Right. So I mean, to pretend as though that it would be off limits, that it would be off limits that to talk about something that wasn't specifically ruled on in the context of an opinion, either in a formal debate or in a kind of informal debate. That's just laughable, Ryan. You're not above bringing all the obvious logical extensions of the opinion.
If it's laughable, you did a very bad job of explaining that to the judges.
Whether I did a good job, whether I did a good job, whether I did a good job, whether I did a good job. Are we talking? Sorry. Hang on. So I just want to be clear. Whether it was I did a good job of explaining. I didn't make that point about whether or not I'm contesting what you just said. What you just said was the obvious thing I would say in the context of in a formal debate is I wouldn't talk about the things that were not specifically holdings of the case, weren't specifically ruled on. I'm just like, no, that's not true. You would talk about those things. You did.
I think that what you're saying is a hypothetical scenario that is outside either the holding or the dicta of the case. In fact, they expressly remanded on just about every factual question. They mostly didn't decide. They gave some guidance and then they sent it back down. The SEAL Team 6 stuff is completely removed from the main opinion. It's not even discussed. There's not even dicta you could point to. There's nothing there. Whereas with the core immunity question, they did say what core immunity is. They did articulate a rule about core immunity, and they expressly gave the pardon as an example of a place where core immunity applies. These are not examples? Parallel examples.
That's not the only example they gave. What's the other example that was actually the holding of the case?
Yeah, it was directing the subordinates to investigate and prosecute crimes.
Right. So there you have some exposition of what a core immunity, or sorry, a core and exclusive, power of the executive is under the analysis of the Supreme Court, and from that, I think that there are absolutely logical extrapolations one can make. You wouldn't just say, oh well, communications from the president to the DOJ regarding election investigations, that's what's the only scope of what was talked about in the Supreme Court opinion is the specific context of what was Trump's allegations in the indictment by Jack Smith. If all of a sudden we have a question about Trump ordering the Department of Justice to investigate Biden for the auto pen situation, would you be like, well, the court didn't specifically rule on? It's some level of generality, Ryan.
Yeah, but the level of generality doesn't apply. We do know what they ruled on, and you said yes. The directing subordinates about the prosecution and investigation of crimes, core. We know the pardon powers, core. Recognizing foreign dignitaries, I would say is core. But
you would say that is core. Where do they say that?
I think that seems likely from the opinion. It doesn't seem unlikely to me.
You're quite willing to say that in terms of likelihood, but not commander-in-chief.
But in terms of the military, as you know, because we've talked about this, I think 3 or 4 times, there are some very open questions about what is and is not a core and exclusive power of the commander-in-chief. There's probably a lot of areas that are core and exclusive, but we don't actually know yet because the constitutionality of all the test cases has never been decided. Is it the Wartime Powers Act? Is the one that's the one that limits the president's? It purports to limit the president's capacity to take military actions. And we don't know whether or not that's constitutional. I think every president has said it wasn't, but it's never been litigated at the Supreme Court level. So whether or not something is going to be a core and exclusive power or it's going to be, a shared power that has the presumption of immunity, I don't think is a given in the military context, and certainly wasn't decided by that opinion.
I'm shocked. Like, regardless of whether or not it was decided by the court, surely you have an opinion about this, right? You're saying you won't have an opinion about what is a core and exclusive power, separate part from what the Supreme Court tells you?
I mean, are we going beyond the scope of the debate prompt now?
Well,
right.
Hang on a second. So whether or not Trump for the United States was rightly decided, in your mind, right? I mean, it relates to your overall notion of what the, what the immunity stands for, what it stands for.
Do you think they decided whether military action was core and exclusive or shared?
They did not.
Do you think they decided that?
Wait. So I'm not saying that they held that being the commander in chief was a core and exclusive power of the presidency. That's not what I'm saying. But I'm saying surely you have a view on regardless of whether the Supreme Court specifically held something, that you have to make a way to make sense of it in your head. And so it's a little bit of a cop to say I can't say anything until the Supreme Court specifically rules on it.
No, I
have an idea.
I have ideas. It's never been, to my knowledge, it's never been litigated.
I'm not asking whether it's been litigated.
No. But this does make a difference, Pisco, because when I say that I think the immunity decision was rightly decided, that doesn't mean I thought about it and as a lawyer had a hunch. It means I listened to oral argument. I read the whole thing. I read the briefs. I read the briefs below. I thought about it pretty deeply. I read the cases they cited, and I came to a conclusion that, yeah, I think they got this one right. When you're talking about something that hasn't been briefed, I don't know that much yet.
I mean, you said that they're wrong about a major part of the opinion, which is the notion that we could put up the evidence of a president's official acts to prove some other.
I think they're wrong. It's a little. Now we're going to really get into the technicalities here.
No. This is not a technicality. So just the audiences, so they're tracking a major component of Trump versus United States. A whole section of their analysis has to do with whether or not you're allowed to use evidence of official actions, whether core or otherwise, to prove elements of other crimes. So, for example, the best example there is bribery. And why don't we use pardon there? Whether you could use the motivation behind a pardon, that is the motives behind a pardon, to prove like a bribery. And the Supreme Court said in so many words, you can't question and use as evidence, the motives behind a pardon, even to prove another crime, and that you can't use it as substantive evidence, not to charge the specific pardon, but to charge some other conspiracy or bribery or something like that. And Amy Coney Barrett, she styles it a concurrence, but it really is a partial dissent, says that that's wrong. And for the longest time, you seem to suggest that you supported Amy Coney Barrett's concurrence, and that differs in a major way from the majority.
I think I couldn't tell if you were conflating two things. There's two parts. There's the motivation, that you can't use motivation to determine whether it's official or not. And then there was the evidentiary rule. You said motivation and evidence. We're just talking evidentiary rule, right? Just to make sure we're on the same page.
The evidentiary rule, but where there's a potential to be looking at the motives.
Yeah. Okay.
So when you're used as evidence, you're like kind of questioning the purpose behind why a pardon was used, not to charge the pardon itself or to determine whether the pardon is official or core or not core or official. So that's in that way, it's not specifically motive, but just as substantive evidence of some other crime. Amy Coney Barrett said that's the right way to do it, and you said you support Amy Coney Barrett. That's a major divergence with Justice Roberts.
Yeah, so I've always said that I preferred her concurrence, and I preferred her concurrence on that issue in particular. When I was prepping for the debate, I noticed something that I was like, oh shit, I should talk to Pisco about this. And then it was like, I'm not talking about this during the debate because it's like so fucking deep in the weeds. When the majority talks about the use of evidence, they always say to the jury. And I hadn't actually thought about the meaningful distinction there, because if you're allowed to show the evidence to the judge and have it sealed, right? So it's not going to the jury, because you're asking the judge to decide the immunity question. Like, is this inside the scope of immunity. Is this within the rebuttable presumption? But you're not allowed to use it for the jury. That's a much better rule than if you're not allowed to use it at all. And I
think that's confusion.
Reading while I was prepping, I wasn't sure. Now, the reason I still like Barrett's version better is I don't actually know what that means. Like, I think I'm right about what it means, but it's not entirely clear to me. I think her rule was clearer and better and easier to use and gave better guidance to the lower courts.
I don't know what you mean by clearer or better. I mean, what do you mean by better? By better, do you mean, like, if you mean by better, more in line with the originalist understanding of the, please decipher what you mean by better in this context. I'm not following. That you prefer it more?
No, the concern is that, like the concern always is in jury trials.
So I'm asking you, I don't know what you mean by the word better in this context.
Okay. So I think we're going to have to then back way the F up. The logic of the case, at least as I understand it, and I think you read it differently, but as I understand it, they asked the first question, does the Constitution grant immunity at all? And they answered that question, yes, because of the core immunity. Then, having answered that question, they said, okay, so there is immunity. How far should it extend? They didn't have much to go on there, so they looked at the slim case law that they had available, which was mainly the two Nixon cases and Youngstown Steel. And from there, they crafted the presumption. So I would agree with you that once you get outside of the core immunity question, what they're doing is essentially a prudential analysis based off prior case law. That's how Roberts wrote the opinion. So when you get down to the bottom of it with the evidentiary rule, their logic is about protecting juries because juries are easily confused. So that's why you have evidentiary rules typically, is to prevent the jury from doing something that they shouldn't do. So there is a live question there about whether or not what the majority meant by the evidentiary rule, which I would need to read again. I think I've got it now, but I'm still not 100% sure. I like Justice Barrett's version better because if the concern is about protecting the jury from bad evidence that they shouldn't have, then protecting it through the traditional challenges, presidential immunity, executive privilege, the typical routes that one takes evidence out of the ambit of the jury would be preferable. It seems like it's just a simpler, better, and easier to use rule. But I mean, that's why I think
when you say that her opinion is better, and are you just saying you like it better? And when you say you like it better, you just like it better because it's simpler and easier for the jury, or simpler, easier for? I mean, I just don't understand. I thought better had to do something with whether the decision was correct, not whether or not I don't know. It simplifies things. I can think of a lot of rules that simplify things that aren't better because they're not correct, because they're not in keeping with the originalist understanding of the Constitution. So I guess I'm puzzled here. You prefer Barrett's rule having something to do with its the ease or simplicity of it. Query why that's the case. It feels like Roberts' rule is more simple in the sense that you just can't use it at all. It seems like Barrett's rule is a little, more complicated.
I don't know. I don't know exactly what Roberts' rule is my problem right now. Like, I feel like if Roberts' rule is you can't use it at all, then I definitely prefer Barrett's rule because I think his rule went A, too far, and B, would hamstring lower court judges' capacity.
How do you know it went too far? Because it's all invented, right? This is what I'm trying to say. Is this is not based in some historical understanding of this. So you even saying something like it went too far. How the hell would you know? Because and that's part of the evidence I'm saying. This is all fucking made up because there was no notion historically of this kind of immunity, and then we're just looking at tea leaves.
This is why the order that the case goes in matters. And this is, I think, honestly, our biggest disagreement about the case, though it's just the direction you read it. Basically, like, the only part of this decision that I would characterize as core originalist in terms of logic is the core immunity section. They asked that part was done by the numbers on the way you would do that analysis. Then they got to the point, and Scalia's been open about this, that originalism isn't like a magic trick. It's not perfect. It doesn't always, you don't always have an answer. And Roberts isn't even an originalist, so of course he didn't write that way. So, once you have core immunity, then you have a question of well, we know there's immunity. How far does it extend? And the tools they have are their precedent. That's it. It's precedent and it's prudential. They don't have a lot to work with. So in that space, they are crafting a decision. The problem that I have when someone like you or Destiny says that this decision was unmoored from the Constitution is that you're coming at it from the end instead of the beginning, because the beginning is when they did all the constitutional analysis.
So let's deal with that.
The second half, I would agree with you, is prudential. Like, I think that's what they were doing.
Okay, so let's deal with this whole notion here. I think it matters whether we refer to something. So Barrett says that the term immunity, she puts it in scare quotes. That is always an indication, I think, that at least in Barrett's mind, that the term immunity here is not standing in for a traditional understanding of immunity, but as a shorthand for something that is not immunity. And she says she identifies two things that the term, in scare quotes, I want to repeat. Guys, if you don't know what scare quotes is, I'm trying to learn from Ryan's amazing example in the debate, which he easily won. Scare quotes mean like it's questioning, right? So you might put one term in quotation marks to indicate some doubt, and Barrett puts immunity. I might even just pull this up to read from it at some point, but I'll talk through it in a moment. As shorthand for two concepts. One is the notion that you would get interlocutory review, and that there are some exercises of congressional authority that would be beyond the power of the Congress. That is not what most people understand immunity to be, and I think it's not just a semantic difference. I think it's a difference with a distinction. And I was poking you on these examples, like, would you really call X, Y, Z immunity if it's a normal separations of challenge issue, and you would and like some other officer had interlocutory review? I don't think you would call it immunity. Sorry, and I'll let you respond. This is the quote from the opinion. This is from Justice Barrett's concurrence. She says, quote, "The court describes the president's constitutional protection from certain prosecutions as an, quote, immunity," in scare quotes. This is direct from Barrett. "As I see it, that term is shorthand for two propositions. The president can challenge the constitutionality of a criminal statute as applied to official acts alleged in the indictment, and he can obtain interlocutory review of the trial court's ruling." The fact that Barrett has to spell this out, I think, is some indication that she doesn't see this as keeping with what immunity traditionally means. And I think that those two propositions, if you truly prefer Barrett's distillation in her concurrence, that is not immunity as traditionally understood.
I don't understand what difference you think it would
I'll explain.
have. I'd be happy to hear it. Here's why I don't think it makes a difference. There's an as-applied challenge, and keep taking my own advice. As-applied challenges, the law is constitutional in general, but as applied to me as the former president, it is unconstitutional to regulate me in this way. The answer to that question is going to be answered by the exact same logic the majority opinion gave. So that's not different. It's the same. And then you have a right to immediate interlocutory appeal, which is very rare in the legal system. Normally, you have to litigate a case all the way to the end before you get to take it up on appeal to decide an issue. The right to interlocutory appeal protects the kind of immunity that they want the president to have, because you can terminate the case early without having to go through the burden and the risk and the hardship of actually doing a jury trial or taking it through all the way through motion practice. You can decide whether to end the case early. That is what the immunity the court described is. You have a right to challenge it. You have the majority. I mean, it's exactly, if another case comes before a district court where a president is charged with a crime and they say, "I'm immune," and the court says, "No, you're not," exactly what Justice Barrett said is what will happen. They'll say, "Yes, I am. I'm challenging. I am immune. Interlocutory appeal," and it goes up. It's exactly what she said. I don't understand why you think it's different.
I'll explain why I think it's different. But first, let's just agree on what it would take to show that it's different. So if I can provide you an example where one example that an individual, an officer, could challenge the constitutionality of a criminal statute as applied to official acts in an indictment and also obtain interlocutory review, which you would not call immunity, then I think that we have a problem here. Then I've identified some area where what they're calling immunity or what they're trying to pretend is immunity isn't contained in those two.
No, I don't think that. I don't think that follows.
Why not?
I think what you would need to do is you would need to show me a case where the majority's ruling would be something would apply differently than what Justice Barrett said.
Oh yeah. So I'll give you an example. So take the following. I'm making this up as I go along, but I'm just making. This is an example. Police officer. In a state, and in that state, some shithead prosecutor in that state is trying to prosecute him for running a red light. Okay, that's the conduct. They say on such and such date, you ran a red light, and the officer says, this law, as applied to me, a police officer, is unconstitutional under our state constitution. And I have a right to obtain interlocutory review of this indictment to see whether to challenge the constitutionality of this criminal statute against, let's say, running red lights as applied to my official actions alleged in the indictment, and I have a right to obtain interlocutory review. If a state court said, yes, you do have a right to challenge the constitutionality of the criminal statute against running a red light as applied to your official actions in the indictment, and yes, you have a right to obtain interlocutory review of the trial court's ruling, would you say that that officer has immunity?
If the state constitution provided the same level of protection to that officer as our constitution does to a president, then yes.
Yeah, so I think that's, I'm sorry, I don't agree with that. I think that is not traditional immunity. That's normal separation of powers principles with interlocutory review, which I agree is not the norm. But let me explain how it's different.
Let me give you a simpler example. You can be so much easier. It's well established that there's immunity for example, like a legislator when they're speaking on the floor. Right, there's a lot of immunity that comes for a legislative privilege. If a legislator was charged with a crime and said, "I am immune to this. I have a right to interlocutory appeal. This law is unconstitutional as applied to me. You can't do this," and took it up. Of course, it's the exact same thing. It's the same procedure. No, but like that's how this works. That's how you litigate these cases.
There's an additional hang on, but there's an additional difference between these two situations. So in the context of a police officer, right, the example I just gave, or suppose this ruling didn't come forth, there would actually be an opportunity for the officer in question, here my example, a police officer, to, using the facts of the well-pleaded indictment, you can say whatever, to say, as alleged, was it actually within your authority to do X, Y, or Z? That's what a court could determine, and they could determine on an interlocutory basis. The added bonus that immunity gets you is now it insulates, as long as you check a certain box, that is to say, okay, in the context of a legislature, you were speaking in Congress. We can't even inquire as to whether what you were saying in that context at all was an exercise of your authority under the speech and debate clause, whether it was in keeping with your legal obligations and the stuff to be imposed upon you. So in other words, to say, like, we don't actually have, we haven't determined whether Trump's orders to the Department of Justice were legal or not.
Yeah, but you wouldn't under Barrett's view either.
I'm not saying that you would under Barrett's view. All I'm just trying to tell you is again, I'm not trying to say that Barrett necessarily agrees with my vision of what immunity is. She's accepting this quote unquote immunity as a shorthand to describe something that is strictly speaking not immunity, which is just separation of powers plus interlocutory review.
But there's no difference between the two, and that's why I'm pointing out to you. Like, the thing you want to have happen is you want to have the lower court pronounce on the legality of the underlying actions before it goes up. But with an interlocutory right of appeal, that would never happen. So it wouldn't happen under the majority's view. It wouldn't happen under Barrett's view. There's no daylight there. It's the same.
No. I mean, listen. So I agree that Justice Barrett is opining on the version of immunity that I think the majority is accepting here. Well, all I'm saying is that's not true immunity. I mean, in a true immunity, I mean, then you must really think like, what is immunity, right? Like, so any individual who can challenge the constitution of an action. So if he wasn't able to obtain interlocutory review, you'd be like, okay, it's not immunity. I mean, like, where is this definition of immunity? It's a proprietary definition of immunity. It's not.
No, the thing that you're leaving out is that the reason that he has an as-applied challenge is because the Constitution grants him immunity, which she agrees with. You disagree with that premise.
Oh my
so
God.
The as-applied challenge in your mind doesn't sound the same, but she doesn't.
I don't think that I'm reaching you. I'm trying to. I really am trying to. So in the normal course, you can challenge a law as being unconstitutional as applied to you, whether you're an official or otherwise. Agreed?
Yep. Yes.
Okay. And that's not immunity. Fair?
No, because I don't have any. I'm not the president.
Well, no, but like, you're putting the cart before the horse. I'm just saying that what Barrett is describing here as the quote unquote shorthand immunity. She says the president can challenge the constitutionality of a criminal statute as applied to official acts alleged in the indictment. That is not a determination as to whether or not they're correct about the core official power or whatever, but just the ability to challenge, not who's going to win or not going to win. So no one would say, right, the ability to challenge a constitutional act is immunity. And to be fair to Barrett and to you, you're not saying that by itself is immunity, but you agree, at least with that proposition, that alone, standing by itself, is not any form of immunity that you're familiar with. It's just the ability to challenge as applied challenge.
Yes, but what you're leaving out is that she concurred with judgment as to the immunity analysis. So she thinks there is an as-applied challenge, but she thinks the as-applied challenge should be decided in the way the majority did. Like, she's not saying that like it's a naked as-applied challenge where we just make it up as we go. She's concurring. She thinks they're right. She's saying there's an as-applied challenge, and when you do the as-applied challenge, the analysis is going to be as the majority told you what it's going to be. Is it official act? Is it a core power? Is it a shared power? That's all stuff she signed up on. Okay. She agrees with all that stuff.
So I'm trying to go after you, Ryan. All right. I'm using Justice Barrett's formulation of her shorthand for immunity to try to gather your thoughts and what it would take to disprove the notion of immunity in your mind. And what you say, for example, when you say the core immunity stuff, that is just, that is untouchable. That is salient. And what I mean when I say, for example, that there is no such criminal immunity in our case law, in our history, what I mean and where the daylight is between them, because there is daylight in the context of an as-applied challenge, right? That we agree is not immunity. And adding by itself, adding interlocutory review of a trial court's ruling on the constitutionality of an as-applied challenge, or the rightness or wrongness of an as-applied challenge, you're saying that adding that interlocutory review makes it immunity when immunity is defined. Go ahead.
In the context of the majority's opinion, yeah. Because here's what I mean. Let's say, because I always do the pardon, let's say that there was a criminalized pardon fact pattern in the future. A president is charged with a crime for using the pardon and is before the district court. They have all the facts, they've alleged everything, all the bad stuff he did. What's going to happen? The president's going to say, I'm immune. What does that mean? It means that this law cannot be applied to me, even if it's generally okay, because I'm a former president and it's regulating my pardon power in a way that's unconstitutional. And I have the right to litigate that. And if the judge says, no, I think you're not immune, I have the right to take it up, and you don't get to decide. You don't get to send me to trial. We don't decide any facts. It goes up before you do that. That it's the exact same thing. That's exactly how this would play out.
This is how it's different, Ryan. So to give you an example, if something is subject to what I take to be real immunity, it means that the law doesn't even apply to that set of things, right? There is no way to. It's like a kind of an area where the law cannot touch. And it's basically you're saying you're incapable, right, of committing a crime or doing some kind of legal wrong in this area of stuff. That's what I take immunity to be. If it were just separation of powers analysis plus interlocutory review, we could actually get determinations as to whether or not Trump's actions constituted legal wrongs. That's what.
How?
Because you could say, well, did Trump have authority under the Constitution or under the enabling acts of Congress with respect to the Department of Justice to order his Justice Department to do X, Y, Z, or the third, right? In the context of a bribery situation where
you can do that under the majority opinion. That's what they remanded to the lower court to do.
No, they fucking didn't. Ryan.
In regards to the, I'm sorry, you're right. In regards to the state electors issue, not as to the core issues.
Right, yeah. That they went on to do the core immunity analysis there, but even there, right, we're not judging whether the president's actions did or did not comport with the law. We're just asking whether or not like it's in an area where the president is immunized, because like immunity isn't just, and this is what I want to get through to people, isn't just did you do something legal, right? Immunity is protection from what would otherwise be like illegal stuff, right? Like it would be useless if all immunity did was like protect you from doing things that were within your lawful power. If all immunity is the right to be free from liability for lawful actions. You don't need to be free from liability from lawful actions. They're lawful actions.
But Pisco, my point is, let's say scenario A, we call it immunity like the majority does. Trump is charged with a crime. Mm-hmm. And let's just, for the sake of making it simple, it's core and exclusive. Down the middle, core and exclusive. He's charged with the crime. It's core and exclusive. He files a motion and says, this has to be dismissed because of immunity. The judge says, no, it doesn't. You're a terrible person. I've looked at these allegations. I think it's outside of I think it was an unofficial act. No immunity. He appeals it. The lower court stops. They litigate it up. And if he has immunity, the case is over. If he doesn't have immunity, it comes back down. In Barrett land, the exact same thing happens. He comes into court and says, you can't do this to me. The Constitution, as applied to me, does not permit it. They say, we think it does. He makes his arguments. The court says, no, it does apply to you. And then he gets an interlocutory appeal. The case stops. There is no finding as to the underlying legality or illegality of his actions because the case stops on the interlocutory appeal and it goes up and comes back down. It's the exact same thing.
Yeah. So no, I don't think so. It's presuming, right? It's presuming this dichotomy that Roberts presents at the beginning, that the motivation behind an action can't change fundamentally whether that action is official or not. When of course that's not true. When of course that one's intent will often change whether an action is official or not, or at least whether it's the use of authority or not. Like the only thing that separates a bribery from in the case of a pardon bribery from from an otherwise normal pardon is the purpose behind the pardon. Right? It's legal to accept money. It's legal to pardon. The reason why you're pardoning, that's what makes it high crime, right? Bribery is a type of high crime. And I understand that the notion is that there's some unofficial conduct there, but that's putting the cart before the horse. In the situation that I'm presenting about what the law should be, the courts would have an opportunity to determine, hey, is sending a DOJ investigation to assist a presidential election of an individual, is that legal? Is that does the president have the authority to do these to order a prosecution for the purpose of helping him with the election? The court could actually determine that legal issue as opposed to taking a step back and saying, oh, We can't inquire into motive to determine whether it's legal, determine whether or not it conflicts in the separation of power sense. We're just going to say, talks about DOJ, talks about ordering. Okay, so we don't have to actually run an analysis regarding whether or not this conduct is legal in the first place. If it were, rather than immunity, normal separation of powers plus interlocutory review, if that's all it was, then really, if it's all it really was, then the court could determine, as alleged in the indictment, okay, is this allegation a violation of separation of powers as alleged, including the motive, including the reason why one might use the power? And that can run up on interlocutory review, and we could actually have a determination, not just whether the powers invoked by the president, as invoked are official, but whether as applied, actually under the facts as alleged, it was legal for the president to do it. And it's a big distinction, in my opinion.
I think that I'm trying to make sure I'm following you correctly, because I think we agree that the as applied challenge plus interlocutory appeal is procedurally the same way an immunity challenge would play out. Like that's the mechanism that they're describing. It is the same mechanism. And what you seem to be taking umbrage with is the part of the decision that a court cannot inquire into sham/motivation when deciding if an act is official or not official. Is that seems to be what
and
you're
basically
getting at.
The facts as both that and I guess the broader factual context as alleged by the indictment, that the court must be able. Well, not anymore, because technically, again, this could be the ultimate Ryan Trump card. You're just wrong because the Supreme Court said so. And I guess, to that extent, I'm a legal realist before I'm whatever. Anyway, but yeah, in so many words, the big problem here is we should be able to do a separation of powers challenge on interlocutory review. Sure, I would even agree with that. But the court should not be limited to this circumstance where we're carving out spheres of immunity based on the invocation of an official power. They should be free to inquire as to the motives of the president to determine whether or not it's legal, and also inquire into the broader factual context to see if the separation of powers challenge is successful, just like they would in a normal separation of powers issue. The APA stuff, the facts matter as alleged, right? In some kind of challenge on the legality of like whether Trump is deporting these people to Guatemala legally, the court is able to consider what is that the affidavits, is it legal to do? That's normal, but it's abnormal to have these like spheres of carved out activities unrelated to motive and broader factual context to determine the metes and bounds of the separation of powers.
So the just to make sure we're like taking my own self-criticism and tying the bow for the audience.
Yeah,
I don't think we're now talking about the gap between Barrett and the main opinion, because I don't think you can correct me if I'm wrong. She disagreed about the evidentiary rule and didn't join as to that section. I don't think she didn't join as to the rule about no inquiring into motivation or
So I'm using Barrett's opinion in two ways. The first way is to push you on the evidentiary stuff, say you actually do disagree with the majority on something major, but you then said, well, I think it all starts from the initial proposition. And then I'm like, okay, let's deal with that first. And then I said, and now I'm using Barrett's opinion for something else, which is just to outline what is meant by immunity, quote unquote immunity, or what one might take to be immunity as a demonstrative. I'm not trying to, in the usage of this context, show some daylight between the majority and Barrett. It's just to illustrate what is immunity in my mind and what is not immunity. I think what Barrett is, and I think Barrett is, I'm not saying that Barrett's stupid. I think Barrett's conscious of the fact this is not true immunity. That's why she's putting it in scare quotes, dude. I think it's obvious that she understands that what's being referenced is in traditional immunity. Though I do think that it's acting like it in the majority opinion. I will say that they are acting as it's a traditional criminal immunity, even though it's not. But
I think the meat of what you're getting at is that there's a section in the opinion, again, I'm just laying breadcrumbs in case people haven't read it recently, that says that when a president is charged with a crime, the first question you have to ask is, was this official conduct or unofficial conduct?
Right.
If it's unofficial conduct, there's no immunity at all. If it's official, then you get into the is it core or is it not core analysis, and that determines what level of immunity there is and whether there's a presumption that can be rebutted. So the gating question is official versus unofficial. And in that context, that they said that the court said that you're not allowed to inquire as to the motivation or whether or not the president was acting like a sham when he did that. And that's a tough rule. I'll admit that's a tough rule. The reason it exists and the reason that it basically has to exist is that if you, in the absence of that rule, there basically is no protection, because you can always allege, you can always charge that someone was acting in bad faith. It's always available to you. So one of the core rights, the right to have an interlocutory appeal early on in the case, before you have to go to trial to find facts, is that aspect. And if you can't determine whether they have immunity until after the trial is over, then a lot of the reason why we give immunity in any context is to protect people from the burden of going through long, expensive, horrifying criminal trials or civil trials, as the case may be, which is a massive burden on them. So that's the problem there, is if you don't have that rule, then essentially there's no immunity left.
Hang on a second. But that's the purposivist / policy argument that you're giving me. Right. So it's not getting at so the separation of powers is maintained. You're not actually criminalizing a pardon if you can get to the quote right conclusion at some point in the proceedings. By the way, I think if you tried to do one of these ridiculous hypotheticals of, like, Congress directly, criminalizing a pardon or whatever, I think you could have not just an as-applied challenge, but a facial challenge on something. And if it were a little bit more nuanced, maybe you'd have to go to trial in some cases to determine that, or maybe as alleged, even on an interlocutory basis, where a court could determine that the allegations in the indictment, that there's the separation of powers issue is apparent just from the face of the indictment. I'm not, lying to you to say that, like, whatever, that they could impose some burdens on former presidents. I have to say, though, that was I think the overriding assumption by most presidents, for whatever that's worth to you. But just put that aside, the separation of powers will be maintained, because the separation of powers will get to the right answer. We'll get to the right answer whether this was authorized under the framework of the Constitution, and either way. And so the only thing that you're bringing back, like, well, it would be really burdensome to force the president to do this at this stage of the proceeding versus at that stage of the proceeding. And so what we need to do is we need to carve out an immunity structure that insulates the president even from things that are illegal. And in that sense,
immunity only protects the president from things that are illegal.
Boom, right? So like, in what sense is it?
What else would it protect the president from?
That's my point. So that is my point. That the immunity doctrine is serving not just to carve out spheres of action that are legal and overprotect them and give them additional protections. It is carving out things that are illegal. And in a normal separation of powers concerns, we don't do this kind of separation of powers an analysis where, like, we're letting illegal actions stand in the way of prosecutions.
No, I mean, as I read the opinion, and this is, we don't need to get into debate tactics again if you don't want to, but I was surprised you let me fight on core immunity the whole time, because that's obviously I think, in my mind, the strongest part of the decision. But I would agree with you that the way the logic of the opinion is, first, they decide, is there constitutional immunity at all? Having decided the answer is yes, there is constitutional immunity, then they start getting into a bunch of prudential questions. And the prudential questions are not derived from, like, constitutional structure. They are derived from the case law, the precedent, and prudential concerns, policy concerns. Like, I think that's what they were doing in those sections of the opinion. And I think they had to, because I don't think there's much precedent to work with. But I do think that that's obviously true. I think that the analysis proceeds differently because they were doing different logic. And the reason, I think, when most people who really, really hate the decision, they hate it because they come at it from the end and they ask, does this rule, is this rule mandated by the Constitution, rather than asking, is immunity mandated by the Constitution? Yeah. And if it is, then what are we going to do now that we know that there is immunity? How should the doctrine develop?
No, my starting point is I disagree that immunity starts from the beginning. I think separation of powers is the concept that's embodied in Youngstown. Separation of powers is the concept that's embodied in, for example, Marbury versus Madison. That's what started at the beginning, and it's the court's, I think, deceptive conflation between separation of powers and immunity. Separation of powers, which of course is going to consider the broader factual context of a given situation. A separation of powers, which of course is not going to, in general, except for when courts, in the rare instances where courts are deprived of Article 3 authority to review a separate situation. Only then, right? Like they're going to resolve whether something is illegal or not. And normally, the courts are well within their powers and do sort of judge the metes and bounds of congressional overlap with executive power. That's not typically the context where the court will defer from ruling. It's typically in the political question doctrine. It's typically
but when there's no overlap, when in court immunity, they're saying there's no overlap.
No,
they're saying it's just executive. Then of course,
but the court is well within its the court is perfectly within its power to resolve whether or not the president has authority to do X, Y, and Z. That's what they were doing in Youngstown, right? That's what they were doing in Youngstown.
Yeah, but that's what this decision requires. Like when a case comes, they're going to have to ask, where does this fall?
Right. So the only thing they were refraining from doing. Sorry.
Yeah. Then when they ask, where does this fall? Then they'll say, oh, okay, this is a core power. Therefore, Congress can't criminalize it. Therefore, out the door, you're done.
But they didn't stop just there. They said beyond normal separation of powers, which they could have done. They said when a president gives an order such as this, the mere fact that he's invoking that power means that you cannot inquire as to the broader motivation for why he's doing something, his intent behind invoking that power, and other factual circumstances that might basically undermine the success of a separation of powers concern, and basically giving a carve out not just for legal action the president might do, but illegal action the president might do.
So the reason that you need that rule, and I will be candid, it's prudential, is let's say President Trump found any one of the million silly violations one could think of that Biden might have done. Let's stick with something that's like is out in the open or whatever. Let's make it's the documents case. Mm-hmm. He's like, fuck the Her report. I don't care that he's old. We're gonna take this one all the way to the mat. We're taking it all the way to the mat. And then when they go to court and Biden says, look, obviously I was acting in my official capacity when I was holding these documents, and obviously I was acting as the president. And they say, no, we are alleging that you are a malicious son of a bitch. We are alleging that you did this in bad faith. We are alleging this is all a sham. So we get to have a whole trial about this to determine whether this was a sham or not. And you know where we're going to do it? We're going to do it in the reddest, Biden-hatingest, most fucking GOP district we can find. And we're going to find 12 jurors and we're going to charge you with something. And at the end of it, they're going to fucking convict you. Now, you can appeal it and you'll probably win, but you might do it from a jail cell. This is not the sort of thing that is at all what we want.
That's what I mean. It's prudential.
I've agreed with you. I've agreed with you that part's prudential. So I don't know why you're.
But that is what I'm trying to offer you is a way in which you're very correct. It's correct. I don't want Congress to be doing something it's not allowed to do under the Constitution. I don't want Congress intruding on powers that are exclusively given to the president in a way that's unconstitutional. But that's resolved, and we can entrust our system. We entrust this with every other public official. We entrust the system to protect all of our rights. And there will be some in areas potentially though I'll note we haven't had it in the past, other previous prosecutions of presidents. So I'm not so sure that we, from a prudential stance, that I'm more worried about the parade of horribles that you're suggesting than the parade of horribles that we're seeing right now, frankly, that I think is at least partly a result of this ruling. So, I mean, we can have a fight over what we're more apt to be scared of. Are we more apt to be scared of a president run rogue or a system run rogue on former presidents? I'm not convinced that your parade of horribles is worse than mine if we're just going off of prudentials. But all I'm saying is, my suggestion and the dissent suggestion is not ignoring separation of powers, is not ignoring that there could be criminal indictments as applied to the president that would be unconstitutional. No doubt about that. And I'm happy to admit that. It's just saying, well, what does that look like, and what does the law require? Does the law require us to create this zone where we're protecting illegal actions by the president? I don't think it does. And I don't think there's any source from the founding or the framing that suggests that that's what we need to have. What we need to have is absolutely separation of powers challenges that we have for everything else. But that's not immunity. And the key distinction is more than just interlocutor review and constitutional review is the court will actually inquire into the legality of the action in the first place, which they're banned from doing now with respect to core and executive. So basically they're saying illegal core and executive power, exercise of core executive power cannot be targeted by Congress. Well, why?
No,
if it's against the law.
It can't be against the law. That's by definition. Like, if Congress doesn't have the power to, this is what I was trying to explain this is why I didn't get to 3-0, is because I didn't land this plane with the third judge. This is the thing I've been thinking about. If Congress doesn't have the power to criminalize the behavior, it can't be illegal. There is no federal law against it. That's the point. It's not, you're going backwards. If it's, and again, this is core and exclusive again, but when you're talking about an area where Congress just lacks authority, they can't make it illegal. But
hang on a second. We know that can't be true. So I'll give you an example. We know that it is against the Constitution to do a racial-based criminal prosecution. We know that, right? Agreed?
Sure.
Okay.
Yeah.
So if the president ordered the Department of Justice and the Attorney General prosecute that man right over there because he's black, find something. He's a black man. Go prosecute him. That is an illegal action. Agreed? He is violating the Equal Protection Clause.
The president's action was not illegal. The prosecutor's action is.
Sorry. So the president, therefore, so you're saying when the president violates the Equal Protection Clause by... Well,
sorry, are you talking about statutory? Like,
no.
We're talking about criminal law here.
Yeah.
You cannot charge someone with a crime. Like, the president violating the 14th Amendment is not a criminal offense.
No.
So you got to talk about criminal law if we're talking about immunity.
So sorry. So you said beyond, we're not talking about criminal law, but right in this context. In a second, I'll introduce a criminal statute that would criminalize this conduct.
I'm talking about criminal law. So if we're talking about something else,
no. So we said, you're like, I said that this immunity protects illegal actions. And you said, but this immunity doctrine makes it not illegal. And I said, that's not true. Let me give you an example of not a criminal act, but an illegal action that a president could take with respect to prosecution that would be covered by this immunity doctrine. And I gave you an example of a prosecution that he could order.
Pisco, I'm talking about criminal immunity because we're talking about criminal immunity. If we're talking about something else,
so hang on a second. So I just want to make sure that we agree then. Like why don't we just agree on something, right? So let's just clarify it. Do you think that the scope of this immunity means that any prosecution that the president orders is a legal action?
I don't understand the question you just asked.
So an action can either be legal or illegal. Fair?
Yes.
Okay. Yeah. So,
and in the criminal context, it's only illegal.
I'm not talking
in the
about
federal criminal context. It's illegal because there's a federal law making it a crime. That's what illegal means.
There's a notion of legality that goes beyond criminal and non-criminal. Fair?
Yes.
Okay.
Yes.
So when I'm basically seeing whether or not it's true that this immunity doctrine is defining the scope of what is legal and illegal, which seemed to be your suggestion. So the example I'm providing you is.
Yeah, I'm trying to skip past this because I have to clarify.
Why?
Because I've clarified to you. I'm talking about criminal law. No, I'm not talking about like civil law, which is a different decision.
But what, I'm interested in this. Can we inquire into this?
Sure, we can. I don't see what it relates to, but we can. Okay. Sure.
So the president, if he orders a criminal indictment and says, prosecute this man because he is black, I don't like black people, is that illegal under the Constitution? Prosecute this Jew because he's Jewish.
Is this illegal? Like, you mean like in some platonic sense? Like, what are you asking?
No, under the Constitution
Okay.
that says that Congress shall make
so
no law
if
respecting
you
an establishment of
challenge,
religion.
if you challenge the law and say you must stop this prosecution because it's unconstitutional, the answer is yes, that would be illegal.
I'm asking, in your opinion, is it illegal for the president to order a prosecution because someone's a Jew? Say, this person is not a Christian, he's a Jew, prosecute him. Is that a legal action?
Does it violate the Constitution is what you're asking?
You should, yeah, of course it does, right?
Yeah, it sounds like it does.
Okay. So in that situation, that would be an illegal action. So now I put it to you, right? Like, let's say that Congress passed a statute that said it is a crime for any person acting under authority of the United States to order a criminal prosecution based solely on the religion of an individual. It shall be a crime to do such.
Yep.
And lo and behold, they charge a attorney general for it. They've had evidence that attorney general says, yeah, prosecute that guy, he's Jewish. Another, lower level prosecute him, he's Jewish. Okay? Putting aside whether Congress has the legislative authority to do it. If they said, okay, now let's go after the president. We have him on tape saying prosecute this guy just because he's Jewish. And this immunity doctrine comes up. What's the result? The result is, of course, he's immune, isn't it?
Yeah, of course.
So
because Congress lacks the power to criminalize the president in that context.
Okay, but that's an example of the immunity protecting illegal action.
Well, no, it's illegal in general. It's not illegal for him to do it. In the criminal sense, it is not illegal because the statute that Congress passed is not constitutional as applied to him. It does not apply to him. So it is not a crime for him to have done what he did. But if you're saying it's my point civilly, he'd immune to a civil suit anyway. If you're saying like in some general sense, is it unconstitutional? And the answer is yes.
So here's the point that I'm making. Here's the point that I'm making. Even though the president is without authority to issue such a directive, he cannot violate legally, right? He doesn't have the authority to issue a prosecution on the basis of religious adherence. The immunity doctrine is protecting him for that, even though he is without authority to do so. Why? Because apparently some part of the Constitution is more important than the other. And that's what I mean. It, by definition, the immunity doctrine is...
No, and this is, I mean, amongst our most significant, I was going to go in the weeds on something else, but I don't want to tangent. Amongst our most significant differences in terms of our legal theories, you seem very uncomfortable with the idea that there are things that various branches of government just can't do. Like you're very happy to say that the president can't do something, but the fact that Congress can't criminalize it is also part of the system. And the fact that sometimes there's things the courts can't or shouldn't review is also part of the system. Like, I think, and I mean, maybe this is just the tangent that we're going to have to go on. Like, I suspect that like when you read Justice Jackson's dissent in Casa, you were like, hell yeah. Like, I think that you view the law as...
No, I didn't even read her dissent, so...
It's really bad, but
okay,
we can talk about that another time.
By the way, you going after my sympathies, what I'm like apt to do, it's not relevant.
I'm not talking sympathy. I'm talking your judicial philosophy. You seem uncomfortable with the idea, and this has been a running theme in our conversations, that there are certain times when the Constitution's delegation of authority means that we aren't going to get to inquire into things. Like, if Congress just lacks the power to criminalize an action, we're not going to inquire whether it's criminal.
I'm sorry to say this. I don't view that as relevant as the point I'm drawing. Like the point I'm drawing is pointing to is that even when the president is doing something illegal, right? I'm not saying that the court has the power to review it. I'm not saying that. I'm not
illegal,
saying that,
but not criminal.
Okay, you're being circular because all I'm saying is that illegal action that the president is not authorized to do, that this immunity doctrine protects him
criminally
from
Yeah.
taking even illegal actions, which he has no authorization to do.
But it does not prevent you from bringing a lawsuit to stop the prosecution because the prosecution's illegal.
That wasn't my contention.
No. So, yeah, because the only thing that matters in the immunity context is the criminalization of things. So, yes, you cannot criminalize something Congress doesn't have the power to criminalize.
What I'm trying to contradict is you're saying that this immunity doctrine is defining the scope of what is legal and what is not legal.
What is criminal and what is not criminal.
What are you able, right. So yeah, obviously the immunity doctrine is preventing you from criminally charging certain conduct. That I don't disagree with, but it's preventing you from charging criminal conduct even when it's outside the authority of the president and is illegal to do. And a normal separation of powers analysis would not do that.
Well, if Congress lacks the power to criminalize the behavior, then you cannot send someone to jail for that behavior. We agree on that, right?
So
if Congress lacks the power to criminalize something, you cannot charge and convict someone with a crime in that area, right?
Under normal,
generally,
if Congress is without a power to do a thing, then they're unable to do the thing.
Yes, of course. Okay. And that's all we're talking about here. Congress lacks the power to criminalize core function. So when they do so through some creative means that has some broad law that is, as applied, seems to criminalize these core functions.
Here's the question, Ryan.
They lack that power.
Why is Congress lacking the power to criminalize things that the president can't do and isn't authorized to do and for which it would be illegal for them to do?
Because what you're asking now is whether the president has the power to do these things.
No. I'm asking, why is Congress disabled from criminalizing or from regulating things that the president
because then we have.
Let me finish the question. Why is Congress disabled from criminalizing or regulating things that the president is unable to do and for which the president, it would be illegal for him to do that?
Because, Pisco, what we're talking about is whether Congress has power over an area, right? Not whether it's legal or illegal. We're talking about, does Congress have this particular power? If the answer is no, then they cannot act. Just like in your example, if the president is taking an unconstitutional action, there are remedies to prevent that. That's what most lawsuits against Trump are the Trump administration, I should say, are lawsuits to prevent unconstitutional actions. That's what that's for. The question about immunity is merely whether you can charge him with a crime afterwards. And the question is, does Congress have the power to make that action criminal? Whether or not it was right, wrong, constitutional, legal, if Congress lacks the power, then they lack the power. It doesn't matter whether or not I like the action or you like the action or it's constitutional or not. If they lack the power, they lack the power. There's nothing else to talk about.
Yeah, so basically what I'm highlighting is, yeah, there are some, it looks like there are some spheres that Congress can't act in, no doubt. I just don't see the reason why we should think those spheres include illegal conduct by the president. Why should they? What's the historical basis to think that Congress's disablement from acting
if Congress passed
illegal things?
If Congress passed the law that said no one shall do official business on Sundays and the president pardoned someone on Sundays, then that was illegal. He should go to jail for that.
I don't know. The court didn't answer that. I'm sorry. I don't see how that's related to what I'm saying.
It was in their beginning. But let's say they say the Congress shall not direct the DOJ to investigate anybody on Sundays, and he asked them to investigate on Sunday. Sorry, no one shall direct anyone to investigate anything on a Sunday, or even broader, no official business of any kind will be conducted on Sundays.
Yeah, that's I don't see how is that in keeping with my example. That's them going way beyond what I would constitute as illegal action or action that is outside the president's authority. The president is well within their authority to make rules for the government. What I'm talking about is Congress regulating things that the president isn't able to do, not things that they're able to do. You understand?
So your question, you're saying if you think the president's action violates some other part of the Constitution, then it would not be immune.
No, No, I'm saying,
Is that the argument you're making?
no, what I'm saying is, surely, I mean, why is it the case? What is the historical or legal reason why Congress would be disabled from acting as against presidential authorities he doesn't have, right? Or an illegal conduct that he can't do?
Well, he has the authority to direct his superiors. You're saying that it violates the way he did it violates the Constitution, but they lack the power to criminalize it, so they can't criminalize it.
Well,
That's not.
But Congress in general can criminalize, violations of people's civil rights. I mean, they've done that, right? They have criminalized that shit.
They absolutely can, but they can't criminalize the president in certain areas.
Even in the area.
I think we're just circling.
Even in the
I
area.
think we're circling now.
We can
But
move
by
on
the way,
there.
what's funny about this is, in a weird way, I think you're warming up to my treason argument.
No.
Because that actually was my treason argument, if you remember, way back in the day. My argument was that treason could never actually be within the president's core powers. Certainly. Maybe you could say it's not within others, but that was the argument I was trying to develop, was that because treason was defined in the Constitution, it should be carved out.
I'll give you one flower. I like the cross-constitutional analysis here, and I agree to the extent that I'm doing cross-constitutional analysis and I guess whole textual.
Well, I mean, if the 14th cuts out immunity, certainly the treason clause does, right?
Sure, but you can't. But what I'm saying is, yeah, it should be the case that treasonous actions should be carved out. But by that logic, so much else should be carved out, right? Like treason. In order to find out whether something is treason, it requires looking into the motives and intent behind a president, right? Like treason under the constitutional standard is either levying war against the United States or giving aid or comfort to the enemies, right? But but think about this, right? So if you're taking the second part there, so that there's it's a narrow definition of the English law, and you just do giving aid or comfort. Like the president could give a bunch of tanks over to the Soviet Union, and they did so in Lend-Lease in World War II. And in that context, that can't be treason. We're helping an ally in war. But doing exactly the same action 30 years later would be treasonous just based on the motive and intent of the president. So the whole notion of treason requires looking at the motives, which is exactly what Roberts tells us not to do. I'll let you respond to that.
Well, I think that I think the motives and intents point is interesting. I'm not sure how that plays out. I do think that though, if we get into one of these extreme hypotheticals where the president commits some kind of brazenly treasonous act, right, which I think dovetails a little bit with your 14th Amendment analysis, the president does something that is just beyond the pale in that way. Like, I think the example I gave in the debate was he fucking bombs New York City and then defects to Russia or something like that.
Right, yeah. Let's take that.
Yeah, so then the way, and for the record, I do not know what's going to happen in that scenario. This is way outside the decision. But my hunch about how that would be litigated is that they would bring it to district court, and the district court would make a ruling that is either not an official act, or they'd make a ruling that it was, rebuttably immune for whatever reason. Like, we're not worried about chilling the president bombing Manhattan. And then they pick that up.
It's such a fascinating hypothetical. I really like it. But I just think it cuts totally against you. I mean, I think it's a beautiful hypothetical. And I might even agree with your realist interpretation of what a court would do. But I'm just like using the logic of opinion, O'Brien. Like, I agree with you. A court would probably, I'm guessing because it depends on the judge. Actually, I don't know. But it's possible. I think it's maybe even plausible that a court would do what you say they would do. But just think about it, right? Like, let's say it was actually Raccoon City in New York City, and the president had to come to a very tough decision to nuke New York. This is the exact situation, right, in which you would want the president to not be unduly chilled by the use of his authorities with respect to, like, sending the bomber squad to go send the nuke on New York City when it was really in the overall national interest to do so. And the only thing separating, a president, you might say, doing the tough but necessary thing to nuke New York in the context of a Raccoon City outbreak versus nuking New York to help Russia is motive. That is the thing that the court says you can't look into.
Well, you can't look into as to official versus unofficial, is what they say.
Right, but if it's official, and so I mean, we're gonna fight on this fucking on this issue of fucking corn exclusive, but even put aside corn exclusive, like in terms of presumptive immunity, I mean, the test here is like any danger of intruding on the executive. Like, you don't think that sending a bombing run within the interior of the country having Congress regulate that has a risk of intruding into the executive prerogatives? Of course it does.
I think that's what would be articulated in a case like that. Is that I think we're right about this in our hypo so far. I think probably, well, there's a few ways they could go. If they liked my treason argument, you could make the argument that like acts of treason are definitionally outside of any core powers. Or
we have to stop there, Ryan, because we have to stop.
No, but I kind of don't want to put weight on that branch because that's just like a thing I invented, and I'm candid about that. It's just that's like a pet theory. I think more likely is that we'd be doing the analysis that you suggested, which is that they're asking is
sending
the chilling
a bomber
effect here,
run on New York is
chilling executive power in a way that we're worried about.
But Ryan, it's at the level of the power. It's not at the level of the specific application of the power. So, for example, with respect to the conversation between Mike Pence regarding electoral certification, they're not looking at Trump-specific communications with Mike Pence to determine whether those communications are covered with absolute immunity or presumptive immunity or whatever it is. They're looking at the nature of that kind of communication at a level of generality above that.
That's why the hypo is so interesting, right? Because like I think I'm trying to remember the one that you got me to bite the bullet on back in the day. But the one that like is when you're bombing, using the military on the interior. That strikes me as very different than using the military on the exterior. I mean, like, I think, for example,
say that, but the president is using the military in the interior all over to do civilian law enforcement, and the courts seem to be loath to stop him.
Well, I think they were. Well, we already talked. I don't want to circle and be boring. We talked about National Guard in California extensively already. So unless you want to rehash that, I'm going to.
No. I just mean that the president has some amount of, and you're not going to deny that it's. I don't hear you actually denying that it's official. You're just saying maybe it's presumptive. But okay, fine. Granted, it's presumptive.
Yeah, like a bombing run is a little different. But I think that and now we're just getting to like modern day politics. Like if the president ordered the National Guard, as he has alluded to potentially doing, to go to Chicago purely to do local police work, I think the court's going to strike that down.
Good luck,
quickly, instantly.
But the immunity would cover
easy.
that, right? Like if Trump ordered his National Guard to shoot a bunch of people in these protests, to fire on site, if Democrats start to show up at fucking at election booths or some shit, or there would be no criminal liability for that.
Well, I mean, I think if he ordered them to fire on site, I'm not sure that's right. If he ordered them to deploy and there were deaths, I don't think there would be.
These people are active insurrectionists. They're attacking us. They're dangerous. They are considered armed and dangerous. All these people, I'm ordering you to shoot them on site. I think that there's no shot that is not covered.
I would be delighted to litigate that case as the prosecutor. I think you'd have a great chance.
I don't know what you would say. I mean, I would root for you. I have to say, Ryan. I think that's ultimately.
I think that I don't think the court would have a hard time with that one, assuming you could prove it. Now, proving it is trickier, but that's the evidentiary rule where I do think that there is some.
And where you agree with Barrett? I mean, wait, sorry. Let's do that, and then I want to move on to another thing. But let's do this really quick. So it sounds like you do agree that you should be able to use two things on the immunity decision before we move on. One is on the evidence issue. It sounds like you do agree that you should be able to use official acts as evidence, for example, in a bribery prosecution where you would question into why you gave the bribe for the quid pro quo.
So I think, yes, in general, I thought Barrett's treatment of that issue was better. And if I'm right about the narrow reading of the majority, which I am not positive I am, but I'm going to read it again after this to double check. If the majority's rule only applies to evidence before the jury, then I would still feel pretty good about prosecuting that case because I could show the judge all the evidence when litigating the immunity question. Right? Like I couldn't show the jury, but I could show the judge. And if I can convince him there's no immunity, then I get to use the evidence later.
Okay. But that is doing what you're saying Congress can't do, right? Because Congress in that situation, regardless of whether the jury is seeing it, Congress is inquiring by letting the judge do it into the motive of the president's action. None of the rationale of the Supreme Court rests on whether Congress is inquiring into motive via a jury or a judge. I mean, that really can't be your interpretation, can it?
No, I think it would be, well, first of all, I assumed we were in like rebuttable presumption land when we're making this argument, but the argument, like in your example, there was a kill on site order, right?
Right, yeah.
So if you look at the way the majority opinion was phrased, it was phrased as direct. It wasn't like any conversation with the DOJ is immune, right? It's directing your subordinates to investigate and prosecute crimes. If you frame that as direct your subordinates to shoot people in the face, I don't think the court's going to have a hard time getting
but Ryan, the whole point is
there.
These communications were about stealing the election, right? These communications were about it wasn't actually doing prosecutions. It was about threatening to do them and threatening to do this kind of actions to steal the election. So yeah, I guess you could. Yes, it literally does say to do investigations and to do indictments or prosecutions or whatever, but let's remember what actually happened as alleged. Yeah. This was not actually what he was doing. He wasn't, he was being told there is no evidence that we aren't actually doing this. So I just in
the hypo we were suggesting, I was assuming we were in rebuttable presumption land, not core immunity.
Yeah,
land.
Sure.
If we're in core immunity land, I don't think there's any evidence you could show a judge that would make it wouldn't matter, right? So then you're just immune. But if we're in rebuttable presumption land, then the idea would be you could show the judge evidence to convince them that the presumption is rebutted.
I don't think that's how it works at the level of the specific application of the power. I don't think it's at the level of, let me show evidence to Judge whatever his name is, to show that in this case, it would overcome the presumptive, it would overcome immunity. It's a powers analysis. Would generally intruding on this power, would that disturb the executive prerogatives? It is not a kind of factual as applied challenge. And if it were that, then you're getting into the same exact problem that Robert seems to be trying to protect us from. If it's just so granular and so narrow that in all of these individual cases, we're going to have extensive fact hearings as to whether the specific application of a power is overcoming some rebuttable presumption, then why not have the trial? That's the best way to get that kind of evidence and to see whether the as applied the presumption is rebutted. But that's not what's going on here. It's a powers analysis.
And in Barrett's version of things, they would do a version of that, right? What would happen is you'd be litigating what evidence can be used for what purposes based off things like executive privilege and all the various reasons why a lot of what presidents do never sees the light of day in court. So that would be one way of handling it. What I'm suggesting is, and I think we should probably read the opinion closely, if the opinion is limiting the use of evidence in front of the jury, that would be very different than limiting the use of evidence at all. Because if you can use it with the judge, then as a clever prosecutor, you could push this argument. You could say, well, I think this is not core, this is rebuttable. I think we can show evidence that shows why it should be rebutted. Judge, we're going to submit it. We're going to submit it under seal. No cameras in the courtroom, no press, just you deciding whether or not this actually should be rebutted. That would be a much better version of the evidentiary rule than the alternative, which is you can't even show the judge to help the judge decide whether the presumption's been rebutted or not. So I don't know the answer to that question. When I was prepping for our debate and reading the thing again, because I hadn't read it in so long, it struck me that they kept using that phrase. And I'm hoping that this never comes up again and we never have another criminal prosecution. But if it does come up again, I'm hoping that this is a thread that gets picked on and that I'm right about this.
Well, I think you're wrong about it. I think that the court is not suggesting that there's a kind of very granular analysis. I think there is a factual analysis as to whether the indictment is alleging official or unofficial action. I think that clearly, I think based on the special counsel's briefing there, that will be fully litigated and factual. But with respect to the powers analysis, that is going to be a more like legal question. Like, does intruding in general on the vice president's communications with the president regarding election certification, would that have any danger? And I don't think it's quite the same kind of factual inspection that would be at issue in a kind of official versus unofficial versus core kind of analysis. It would be more kind of like, what are some hypotheticals we can think about where it would unduly intrude on the executive's powers. I want to move on to one other thing about the immunity decision, and then I want to hopefully we'll have a point of agreement at some point here. And then
sorry, I'm muted. My bad.
No, you're good.
The other thing that I thought was really interesting, just because I think we're wrapping up the topic, when I was listening to oral argument again, was the risk that a president would just start pardoning himself. Because we also don't know whether a president can pardon himself. The court's decision here seems to indicate that he probably can, but I admit I don't know. I'm just reading tea leaves. So that would be the other the other way that you'd end up with immunity, right? Is that everybody just pardons themselves every 4 years?
Yeah, but I don't think that's constitutional. I think it's fucking absurd. Now, you could say it might encourage people to do that, and maybe the court would sustain such a pardon. But I guess that just doesn't, I think, and shouldn't affect our analysis about whether or not Trump for the United States was rightly decided. Well, but I guess
I think it did, because I think a few of the justices were bringing it up at oral argument, because I think at least Gorsuch, Alito, Thomas think you can. I don't know if they have another two. I think 3 of them think you can. So if you could do that, then the immunity immunity is way better than that. That's like the worst possible outcome. So, I don't know if Kavanaugh or Barrett would have signed up for that. That seemed, I'm not positive.
I
really have no idea.
Do you have an opinion on it? It's like, seems pretty wild.
I mean, if you think the pardon power is core and exclusive, and you're serious about that, it would be difficult to think about why the court
you could say
can put limits on it.
Well, if you say, the pardon power doesn't extend as far as X, Y, Z. But if you say that, it's like,
that's what I mean.
If you can, then what is this, Ryan? Like,
no, but that's what I mean. Like, given the weight they put on the pardon power in their analysis in this decision, it's hard for me to imagine that they would then, in a different context, be like, oh no, there's this clear limit on the pardon power.
But of course, like, courts must be able. I mean, there are some limits on the pardon power, right? Like, people say this, right? Like, but Trump can't pardon
state crimes,
a chair, right? He can't pardon a state crime. Trump can't pardon something where he's like, I pardon blah, 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 where no one understands. Like, there must be some implicit requirement that pardons be intelligible. I actually think that pardons probably couldn't be prospective in the sense of affecting future conduct. I think they can be prospective in the sense of affecting future prosecutions. That is prior conduct, right? But there are some limits here, and the courts need to figure it out. So I just think that we've all kind of accepted this, and it's odd from you because I do believe you when you say you're fearful. I do believe your sincerity when you say you're fearful of an encroaching executive. But like, I think we've all accepted this bizarre version of executive power where like practically every power is unchecked by the executive, instead of like power checking power and like having these specific checks where they are kind of intruding each other and kind of edging each other out. I don't know. I think it's too formalistic, too simplistic. I want to add.
I think there's a difference of opinion. I think we both actually want to check executive power. I think we disagree about what that looks like. I think that one way of looking at that is to have tons and tons of micro checks on the executive, like in terms of, can he fire this agency? Can he hire this guy, et cetera, et cetera. And then the other way of doing it is to say, I wish the executive branch were just a lot smaller. Like, I wish they had less power in less areas, and he just didn't have capacity to do X, Y, and Z, which is actually what the, I only skimmed it, so maybe I shouldn't talk about it publicly, but when I read I skimmed, I should say, the recent tariff decision, they seem to be going that direction, where they were saying, actually, a tariff, the statute says, we're not going to question whether you can declare an emergency. We're not getting into that. But the statute says regulate an import. and a tariff is not a regulation within the meaning of that statute. Therefore, this is just a power you don't have. And that's the kind of check on executive authority that I am very supportive of. So I'm hoping that we get more of that. That sounds good.
I'm hoping that we get more of that too, but I just if it's a power it doesn't have, I just don't understand why Congress can't fucking criminalize that shit. I mean, presumably with some caveats here. Like if the president purported to do kind of like an illegal tariff, knowing it was illegal. So let's even say that there's like a willfulness component there, that he knew it were illegal, not just that he did it and it was illegal, but that he willfully did something he didn't have the authority to do, impose a tariff. And even let's say you add another sweetener for a corrupt purpose, and that is defined as for personal enrichment or for the enrichment of a family member. It seems bizarre to me. Okay, Congress can regulate the president doing a tariff that he and I don't know. Basically, I think that we've carved out this criminal immunity space as a category of its own when there are so many other checks, or there should be checks on presidential authority in the civil context, and it seems that a lot of it has to do, and I don't know why you don't just accept it, not in a robust history of this kind of criminal immunity being anticipated, but just basically because of prudential concerns. So basically, they're afraid that it'll lead to a tit for tat where all these and then you've described this kind of prudential fear of yours before, and so I think you probably share in this fear that we're going to end up in this political prosecution. It'll tear up the country apart, and I just think that has no bearing if we take the
we don't disagree that there are prudential elements of the decision.
Okay.
I think you read the decision as completely prudential, and I read the decision as them saying, should there be immunity at all? Yes, that's a non-prudential constitutional analysis. Having decided the answer is yes, then the question is how far does it extend? And then I agree with you, they were being prudential. I think that's where they were being prudential.
Got it. Okay, let's move on. Sorry, one other thing on the immunity stuff, and then I want to move on quickly to Dugan, because I think we probably agree there. Although I think it might present some problems for you, and then anything else you want to talk about. I know that we've been going on it for at least 2 hours now, so I also want to be conscious of your time, but I'm jealous of the time I have with you, Ryan. I think that these are interesting conversations, despite your fucking assholeness. First thing is on impeachment. Don't you think that any position that would entertain the notion of an indictment post-impeachment for official conduct would be just as anathema to the Constitution? And likewise, why is Congress able to inquire as to the motive of core official duties when it comes to impeachment? It seems like you're having a pretty big carve out for congressional intrusion on executive authorities, either through the impeachment process itself, questioning the motives of official powers through an impeachment, or with an indictment. You're at least, flirting with the notion of an indictment after an impeachment over official duties.
My view on impeachment is that, and I think this is pretty clearly established by the courts, that whatever high crimes and misdemeanors means is whatever the fuck Congress says it means. There's just I don't think there's any check on that. I don't think it's reviewable by any court. I think it is entirely up to the legislature. So if the legislature wants to say, the president ate a ham sandwich and we fucking hate his mustard choice, and they can get the votes to impeach and convict him for that, then he's impeached and convicted.
I agree that would have
I don't think there's any check on that.
Okay, I agree that would have legal effect. And I think that you don't like this next question. It's regardless of whether it have legal effect, would it be a constitutional impeachment and removal? And then
yes.
with the subsequent indictment, let's say that they impeach him for what they say this is a criminal pardon, and they invent some random shit called criminal pardon, and then they pass a statute saying it shall be a crime to do a criminal pardon, and they define it in such a way that it covers what he's doing. They impeach him for it, remove him, and then a prosecutor tries to indict him over that.
I don't think we know. You can correct me if I'm wrong. I think that both sides seem to concede that if you were impeached, you would lose immunity flat stop.
I know. I
don't know whether that's a rule. Or not.
So it's my position that the Supreme Court ruled on this, and they said for the same reasons, you just can't touch that conduct, regardless of whether you're impeached or removed of it. it doesn't change anything. That's Congress going after a former president for stuff, and so it's my position that I think that Congress, the Supreme Court completely rejected the impeachment judgment clause argument from Trump, which is a good thing for sure. But it doesn't help that they kind of gave some additional immunity in the process of doing that, basically by saying,
I don't know. I don't know if I agree with you. I know that they ruled that impeachment is not a necessary predicate for prosecution. I don't think they ruled on whether impeachment
negates the immunity.
Rescinds your immunity. Like the logic there would be like, if you are impeached, it's like you were never president. It's like, fuck you, you've lost it. It's gone.
Okay, well.
So like, I don't think they ruled on that. if I'm wrong, please correct me. I'd love to direct me to wherever
I just think that the holding of the opinion is categorical and doesn't say that you could, I guess it doesn't not say that you would lose.
It doesn't address it. It's just not.
No, but
it's not an issue.
But take the holding, an issue. Why would it make sense, right? Like from the prudential perspective, that they're saying like it would chill an executive to allow for a post-impeachment indictment over core and exclusive authorities of the president.
Are you asking prudentially, or are you asking in terms of separation of powers? What are you asking? I think there's good reasons for both.
Let's go with both. Yeah, let's go with both.
But for the record, I don't know if this is the law. Like, this is just us making shit up right now. So I don't know. I'm not saying this is the case. I really don't know. I think the arguments would be, one, from a separation of powers perspective, if you are impeached, then they'd be asking the question is, were you essentially never the president in the eyes of the law, or is it like you were the president until the day you were impeached?
Do you think that's possible? I mean, like, we're gonna rescind all of the stuff you did before? There's no way they're gonna hold that, man.
I don't know. And then the prudential concern would be like, if the political will is so strong that you got an impeachment and a conviction, which basically never fucking happens, then we've kind of answered our own question about the chilling effect. Like, this is not, people want this to be dead.
Last follow up on that one. What's your opinion there? Would an impeachment and conviction undo the core immunities for the president?
My gut read is it probably should, but I have to admit, like, the problem with gut reads, like, I remember you and I were talking about CASA, right?
Yeah.
And my gut read on CASA is that they should find a way to save universal injunctions. And then I read Barrett's opinion, and I was like, and I read the briefs and listened to the oral argument. I was like, holy shit, she's right. Like, this was like, I totally misread the situation.
Oh, you agree with the majority on CASA?
Yeah. Well, I was like, we talked about, we before the decision came out, we talked about it, and I gave a gut read, and my gut read was entirely based off of my own personal concerns about policy. And I still have those concerns about policy. And then she wrote a decision that had nothing to do with policy, and then said the policy isn't what I'm deciding it's on the basis of. And I thought she was right.
She says that, but she also starts with policy being like, judges across the nation are issuing the da-da-ba-da-ba-da-ba-da-ba. So, like, I mean...
Well, she's giving the factual background.
I think she's being a little bit slippery there, and I'm less impressed with Amy Coney Barrett post-CASA. I have to say, of the conservative justices, she's still my favorite, notwithstanding everything else.
She's wonderful. But I love, the point is, I loved the opinion, and it changed my mind on the issue. Wow. Because going into it, I had a different view, which I talked about last time. But my view here, wasn't informed by some like when I talk about like the immunity decision, we disagree. But I know you've read it, you've read the cases they cite, you've read the law, you've read the Constitution, you've done your diligence, you've thought about it deeply. With this thing, it is just a gut read. So that's my gut read, but I don't know that would stand up if I had to read briefs. And I could be persuaded.
Got it. All right. Next up, Dugan, and then we can go move on something else. I think that it was disastrous. It would have been disastrous if the court had ruled that Judge Dugan has the same kind of immunity that Trump does. But I just don't understand why you're not committed to that. Like, arguably, there's a greater historical basis for criminal immunity for judges. There's at least case law that will say things like you can't indict a judge for her judicial acts. Now, I think that doesn't mean exactly what it is implying there, and I think that the Supreme Court, in any event, overrules that based on other statements that they've made. But I just think I'm glad that the district court found that she doesn't have such immunity, and I think it's disastrous. It would be disastrous to extend it beyond the president, and that I think should give you some
No, I think the scope of judicial immunity, and I mean, I haven't read the briefs, but maybe this is, and maybe some creative lawyer has made this complicated in some way. But to me, this case always was like, seemed really simple, where it's like judges are immune, like for their rulings. You can't like charge a judge with a crime for the way they came out on a decision, right? They that's very different than saying like use that door so the cops don't find you. Like that's not the sort of thing that they have immunity for. So this never struck me as a particularly hard
You
case.
think the immunity only extends as far as their judicial rulings, and that's it? Not like their, order in the court and deciding whether or not to like.
Yeah, like I think if a judge stood up in court and shot someone, that would not be a hard case. I think they'd be tried and convicted. I don't think there's any immunity there.
What about the president? What about the president?
The president just like stood up and
He's
shot
the commander
someone.
in chief. He has some authority to.
Yeah, I mean, I think that would be. I think you'd have a hard time fitting that into.
But like, no, seriously,
his official powers.
If a judge was defending the courtroom from some brigand who's attacking their deputy, I think the judge would be well within their rights as an officer of the court to exact justice in that fashion.
I think they would. I still think they'd be immune.
And the only difference between that and like shooting someone in cold blood is their motive and their intent, and whether it's a wrongful intent. But we don't have to dwell on it. But I'm curious if you have any thoughts on it.
If there's some complexity there that's interesting, I'd love to talk about it. I don't know that much about it, but every time that case gets brought up, I was like, well, that's not. There's no way that's immune. It didn't even seem close.
I think it's an easy slam dunk for SCOTUS. They're just going to say, well, our ruling on Trump the states only extends to the president. We were just interpreting.
It has nothing to do with this at all.
Article 2 doesn't interpret state judges, and they say, and we have all this other precedent where we in dicta acknowledge that this doesn't extend as far as criminal immunity, although they did that for the president as well. Although I think they have officially upheld a criminal indictment as against judge, so at least there's some on-point precedent of them rejecting criminal immunity for judges, which I admit they didn't have for president because we didn't have the history of prosecuting presidents. Although I think, again, if there was a prosecution before this court, they would have said that there's no such immunity.
Has there ever been a case where a judge was accused of like taking a bribe and like falsifying a conviction or something?
Yeah, they've been charged and convicted on that. Yeah.
Do they get immunity for that?
No.
So then, all right, I haven't looked at this. Obviously, I haven't looked at this very much. Like, what the fuck is the scope of judicial immunity then?
You should look at the opinion. I might send it to you, but like,
it's
the same kind of issues at issue. Like here, like it's kind of, we need to have a motive or sham filter. It can't be the case that judges are just like, okay, and it makes sense in the like why should we accept that? Let's say that a judge is ruling and we can prove, right? Like, again, there will be always evidentiary issues of proving that a president did this specifically for a corrupt purpose, and that will filter out a shit ton of bad stuff. And same thing with a judge. But let's say you could prove, I ruled in favor of this mafia person because I was actually a member of the mafia myself. We couldn't use my ruling in favor of the mafia that was done for corrupt purposes as part of the showing that I'm like in a RICO with this fucking mafia. Like it just, to me, like any kind of scope of immunity, and I'll go as far as to say, fuck, even the speech and debate clause stuff, I think should be subject to like a sham filter. I'm not a fan of these having like these unchecked spheres of immunity. I don't even, and I told you as well, I don't even agree with absolute immunity in the civil context for the president as a constitutional matter. I think that should have to be enacted by a statute.
I couldn't believe you said that. I was so surprised by that.
When you said that, that. By the way, that's when you said you're a junior lawyer.
Yeah.
And so I don't think it was some like strategy to unnerve me. I think that you were reacting in real time to me saying I don't agree with Trump versus Fitzgerald.
No, it was so surprising because I didn't quite get exactly what I wanted. I was hoping that I could induce you into going into a long tangent about why Fitzgerald was wrongly decided, which you didn't do. No. But like that was the hope.
No, what I said is like, I mean, it's not just me. There's constitutional scholars that think Fitzgerald was wrongly decided, and I think it's an invention as well. I mean, if you want absolute civil immunity for the president, I think you should pass a law. But it just seems that like the court is willing to, and that was like a more liberal court, or I should say, it's a more liberal era than now, because now I think it's like probably the most conservative court we've seen in maybe 100 years, at least with respect to judicial philosophy. Okay, that's me on Dugan. That's Fitzgerald. We've been going at it for 2 hours and 30 minutes.
I'm trying to read the Wikipedia on judicial immunity, and
you're good.
Judicial immunity does not protect judges from suits stemming from administrative decisions made while off the bench, like hiring and firing. But immunity generally does extend to all judicial decisions in which the judge has proper jurisdiction, even if a decision is made with a corrupt or malicious intent. By way of counterexample, in 1997, West Virginia Judge Troisi became so irritated with a rude defendant, he stepped down from the bench, took off his robe, and bit the defendant on the nose. He pleaded no contest to state charges, but was acquitted of federal charges of violating the defendant's civil rights. He spent 5 days in jail.
Yeah, I mean, this shit's fucking wild, bro. Like, we don't need this. We're a country of laws. They should apply to everybody.
Yeah, sorry, the Wikipedia entry just took like a wild fucking turn. I did not.
Fucking vampire judge. Vampire judge. Brother, is there anything? Let me think of anything. Bones I have to pick with you, or agreements. Let me think of agreements.
Is there any basis in law that you're aware of for the president deploying the National Guard purely for the reason of domestic policing? I can't even think of one. I'm sure there's some creative lawyer who has something, but I have no idea what they're going to say.
I'm not aware. So in DC, I think that there is.
Oh, in DC, yeah. So sorry, taking the own feedback. Breadcrumbs in case the audience isn't following all these things. DC is not a state. DC does not have the same solicitude as a state. There's a lot of the rules about what the president, what the federal government can do in DC are totally different. But deploying the National Guard in a state normally requires some sort of inability to enforce federal law, for example, is what they talked about in LA. Not like we want them to stop domestic state crime. That's not traditionally. I don't know what that would be. That doesn't strike me as.
Yeah, I'm not sure what the federal hook there would be. You know, I think that yes, the laws seem to suggest and state, at least for some of them, either a finding of rebellion, invasion, or inability to enforce federal law. Another one is, the Calling Forth Act with respect to insurrection. So that, presupposes an insurrection finding. I don't know if there's any precedent for enforcement of state law. Although you could argue, right, like the states in rebellion during the Civil War, I guess they were rebelling against the United States, although in some respect, I would gather that the Lincoln administration also considered them to be in like rebellion against their state governments to the extent that the states are.
Yeah, if he actually does it, and like I'm guessing that there's a game of chicken being played here based off like the wording of the flag burning executive order, where he came out there and said some like fucking wild unconstitutional shit, and then the executive order was like actually very carefely worded and didn't say anything. It was very
devious, yeah.
It had nothing to do with what he said. So I'm guessing that he's not going to go there, but if he does, this will be an interesting litmus test.
Yeah, I think he will. I mean, he's running the whole thing on emergencies. And I think the courts, by and large, are uncomfortable, like, sussing out, like, well, what does he really mean to say you're unable to follow the law? And, of course, Trump's interpretation is the only one who can determine whether they can follow, whether we're able to enforce the law is me. And the litigants are going to be like, no, of course not. Like, the courts have to be empowered for one of these predicates. That's one of the bases of the litigation in the Ninth Circuit. I don't know if that's being appealed to the Supreme Court. I think Newsom has requested an in-bank rehearing or re-argument or whatever for that determination.
I mean, but they're not there anymore, right? So I guess they could like.
I think the deployment is still there in LA.
Is it still there? I don't know.
Maybe.
Does anyone in chat know? I have no idea.
Chat, do you know if they're still in LA? I imagine they're still doing their like enforcement shit.
Oh yeah, the ICE is probably still there. But like, is the National Guard still there, like protecting the federal buildings and shit?
I think I would know if the federalization of California National Guard were over. I think that Newsom would like bandy that around as a win, probably. But that doesn't.
I'll have to look into that. That's interesting. I think the Chicago thing, if it happens, will be an interesting litmus test.
Yeah,
I have a hard
for
time.
You, perhaps.
No, I mean I have. again, like, I'd be willing to read the briefs, but like sitting here today, I have a real hard time coming up with an argument for why that would be okay. So I mean, that would be very, very interesting to watch.
We'll see. We'll keep a close eye on it. I tomorrow I'll be covering some more of the tariff stuff. Let me get your. I mean, what are your general thoughts? What's in the zeitgeist? Why don't you tell people what your thoughts are generally on the news of the day, and then you can shout out your channel and we can call it a night.
Nice. Well, first of all, Pisco, we have a lot of fun. I enjoy the
always.
conversations. I enjoy the friendly rivalry. I know we yell at each other a lot, but it's never personal from me. So
The heart
all
goes
good.
out to you.
Yeah. So I just did a pretty interesting conversation with Wick before this tonight that I
Nice.
think people should be listening to because it's a great one, but also I think is in some ways like the most important topic to me right now, which is like America is, I don't think this is debatable, a propositional nation. Our proposition is that there are natural rights that any just government must honor. It's in the Declaration of Independence. This is who we are. And there are forces that are gathering on both the left and right, and on the right in particular right now, who will come in and say things like, no, 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 we're heritage Americans. We reject being a propositional nation. We should be a Christian nation, or we should be an ethnic nation. And I think I think lines need to be drawn about what is a policy difference between the bounds of what is acceptable in an American liberal society and what are the things that are just like, no, you're off the island, bro. Like if you think we're better off in a theocracy, you're off the team. We're done here. And I have the same view on socialism. Like I think that these boundaries need to be drawn more closely than they are. So that's a fight worth picking. So that's the fight Wick and I were talking about gearing up for earlier tonight.
I think the only comment I make on that is like I just don't consider them as natural rights. I kind of view them as preferences. But kind of grounds out into the same area where I think there are such rights, but I don't think that they exist in anywhere. I don't think that they are actual physical concepts or that they are objectively true, stance independently or whatever. But
how do you square that with like the way the Declaration of Independence is written or the way the Constitution's worded? Like, I mean, I feel like these are core American propositions. Like,
I think they are. I mean, and I agree with them, and I think that they ought to be viewed in the same kind of salience I imagine that you do. But I just don't. I'm just talking about their origin. I don't think that they, maybe unlike the founders, I don't think that they exist as sort of natural concepts that can be discovered or found. I think that their concept of American minds, they're good concepts, and by good I mean they accord to my worldview. I don't see them as like objective truths, but I do sort of support generally your adherence to what I think I gather are a lot of overlap.
Yeah, I mean, I think the reason that obviously the founders framed them as objective and, God-given because that's what they believed. But beyond that, there's a real important like philosophical distinction there, which is they are a higher authority than your government. Like the reason we were justified in rebelling against England is because they were violating our natural rights.
Oh, you have to have something like that. You can't just be.
There has to be a higher moral authority than the state, right? And if the state is the highest moral authority, then if the state fucks you over and takes all your rights away, that's not a problem because the state's what gave you your rights in the first place. So the rights, however you conceptualize it, have to be more important than the state. They have to be something
that's absolutely true. And anything less than that, you're just a shill that has no line. And even people who are, at a high level, but I think the difference is there are some consequences, some level of severity by which even I might abandon a principle. So like, it could be the case that there could be, and again, even a principle incorporating all of its exceptions, because of course the values and rights that we all acknowledge and natural rights, I'm sure you don't conceive of as limitless. Those rights exist, and incorporated in the right are certain exceptions, right? I'm gathering, like, you say there's a natural right to free speech.
If you're a purist about this, you become an ANCAP or an anarcho-objectivist pretty fast.
But in general, I appreciate that philosophy, and I think that there's too much power worship among extremes on both sides.
Yeah, I think it's dangerous because classic liberals, and I think that's actually a pretty wide category that extends on both sides, left and right, like people who really take seriously these values have become a little timid over time. Like we often talk about things in terms of legality, where we'll say like, oh, well, you're allowed to do that or you're not allowed to do that, and kind of leave the morality out of it. And it's like when the flag burning order came out. Like, no, I was telling people, like, look, barring some local ordinance about arson or whatever, like you have the constitutional right to burn your own flag. You shouldn't do it though, because it makes you a piece of shit. Because the law and morals are not the same thing. Like I will defend to the death your legal right to do something I think is awful because I don't want the government to restrict you in that way. That doesn't mean I agree with you or I think it's a good thing. And I think that sometimes classic liberals get so in the weeds about not wanting to ever extend a moral opinion that we've let people creep in on the fringes that really need to be ruled out. Like we need to actually come down and be like, you know what? If your view is that there should be a religious purity test to hold office, that's un-American. You're done. You're off the team. If you think, and I know you might disagree, I don't know where your stance is with this, but like if you think that you should just like remove property rights from everyone in the country, you're off the team. Like that's not like these are outside the bounds of what the American experiment is, and we don't need to be cute about it and say like, you know, just because I'll defend your right to say it, I have to put up with it in some conversation and not lecture you about what a moron you're being. I think that's a fight worth having, but you know, that's me.
I mean, I think that property rights are intrinsic to the founding rights of America. You know, it's a life, liberty, and property were the original, like, I don't know, Lockean notions or whatever. I don't fucking know. And due process applies to what? To life, liberty, and property without due process of law. So no doubt there. I guess it depends on what you mean by property. But to me, because I don't view these as sort of natural rights given, I just don't value certain organizations of property as much. But, given the choice between free speech, for example, and property rights, or the right to vote in property rights, I just value these rights differently. It seems like you have a more kind of take it or leave it approach.
Well, this is what the conversation I had with the Connor boy, rest in peace, love him. He's not actually dead.
He's
sorry,
not dead,
but,
yeah.
but you know, gone. Which was I thought was really interesting. Is he was saying like he said at one point to me because I was arguing with him about whether socialism is immoral as an end, not as a process, but like in and of itself, is it immoral? And I was saying it was. He was saying, well, let's say I could take away your property rights. You can't start a business. You can't negotiate for your wage, but everyone in the country is 10 times richer. Wouldn't that be better? And I was like, no, because I view that right the same way I view any other right. Like if you said to me, what if I took away freedom of speech and everyone was richer? Or what if I took away your right to worship and everyone was richer? My answer would be no to all those things, exactly because I actually do think natural rights are objective and more important than the affairs of the state. So I don't like the trade-off doesn't interest me because it's not for me to trade, if that makes sense. Yeah. So I think it does matter whether you view those as deeply held and to what level you view they're deeply held.
Although I find it funny that you are conceiving the natural rights as existing separate from America, but you do appeal to the Americanism of them as like it's fundamentally un-America and therefore bad. But you could conceive of America that turns away from those natural rights, and perhaps you already think that they've done so in some respect. But I guess you're saying it just happens to be the case that the American system in general aligns with your conception of natural rights.
Well, I think that that was our founding. That's what our founders laid out. That was the moral case for our existence. That's what they wrote, is that this is why we get to be a country. And what's useful about that is that I can say then like, okay, well, this is a core American value. I'm not making it up. It's in the Declaration of Independence, for fuck's sake. Like it's there. That's who we are. If you get deep into the weeds on the philosophy, bro, then you've got to have like a fucking 10-hour conversation about like, does God exist? Are we made in God's image? Or if God doesn't exist, do platonic forms exist?
I guess I'm signaling
it's just too much.
You're not saying that just because something is more American or more core to our history or more core to quote who we are doesn't mean it's better. I assume that's a shorthand for something.
Better in what sense? What are you asking?
Well, that's my question for you. Like when you say, getting rid of property rights is un-American, The implication seems to be like, well, that's bad. It's bad.
Yeah, it's immoral. It's immoral.
Right. So I assume it's a shorthand, that not just because something is American, therefore it's good. It's that you're using it as a kind of a reference point to something. Maybe it's these natural rights.
I actually do believe in natural rights. So like when I say that like it is an objective moral obligation, it is actually something that you should infringe as little as possible. I agree with you that there's no such thing as a government that does not infringe at all. So if you're going to have a government, there's going to be some infringement, but we should infringe as little as we can on these rights. And also we don't rule the world. We don't set the terms for everybody else. But I do think that it is better. I think free speech is better than no free speech. I think, freedom of religion is better than no freedom of religion. I don't think it's culturally relative, let's say. I think there is better or worse. That doesn't mean I have the power to dictate people what they do in their countries, but I do think one is better than the other.
Listen, I respect that you're a pretty serious civil libertarian. You'll let me know when that gun to your head hypothetical changes, all right?
Hey, man, if Trump invades Chicago with National Guard, we might actually be able to have another conversation.
I'm not holding you to that, but we'll talk about it when it happens. Ryan, thank you so much for graciously, I guess I'll put it, coming on to it's hard when you came on with the belt, but I do appreciate you coming on. I super enjoyed having you, and I'll give you the last word.
Yeah, first of all, I hope that the comments in the chat doesn't get too fucking crazy about me and Pisco going after each other. It's all in good faith and good fun. Just because I did bring out the belt, I feel compelled to say, after the debate was over, I was like, the next day I was like, I wonder what Pisco thought of it. So I looked up your channel, and the fucking title is something along the lines of "Centrist Lawyer Trapped into Insane Take."
I didn't write it.
Holy shit, hold on. I just won a debate. I won a debate. This motherfucker has the title "Centrist Lawyer Trapped." That's the goddamn. So I was like, okay, I think I'm going to have a little fun when I see
the margin of your quote unquote victory was someone's like, the vibes of Ryan, whatever. Hey, man. And the other guy be like, impeachment. I'm just saying.
Here's another way. Here's another way of looking at it.
Yeah.
The progressive. There was a lefty, there was a righty, and there was
Admiral Gibbs. It's an Admiral Gibbs invitee.
I convinced the progressive.
How progressive can the Admiral Gibbs friend be?
And I love you, but you convinced no one. The dude gave it to you on the burden of proof because he said neither of us proved anything.
Oh wait, so now you're getting into the actual substantive rationale of what they're talking about, and you're not convinced.
Hey. I thought it was fair for him to do so. I thought we should have done better.
Oh, it's fair. It's fair. And if someone said the exact opposite, it would also be fair.
I could have gotten a 3-0 if I had just told him what it means to pass a criminal law. So that's all I had to do.
People could literally say the opposite rationale and be like, you talk too much about this, you talk too little about this, and you'd be like, they're both right because they both voted for you or voted in whatever the way they're going to vote. But anyway, I do appreciate you coming on. Memes aside, good conversations. I'll post this one and we'll see what the title is. Maybe we'll make it something boring so it doesn't get any views.
Yeah, that's always the game, right? If you came up there and me and Ryan have a normal, nice conversation, it's gonna be 3 views, and that doesn't help anybody.
Yeah. Well, thank you so much, man, and super appreciate you, and we'll talk again soon.
Yeah, man. Have a good one.
Later. Okay, folks, it's all over. Well, all doing it. Ryan is not good faith. Guys, chill. Jen, you're always attacking someone. Can you ever just be I disagree with this person respectfully? Jen's always this person is a fucking grifting piece of shit. They probably fucking killed someone before they sure. It's you're always after people. All right, folks, I'm sending you someplace, I think. Enjoy everything. Hope you're enjoying the content. I'll see you tomorrow morning. Stay cool. Bedtime.